see in the
They will log in automatically. They should know the sanctity of time. Once we are talking of timeline session.
Yeah, you're nice.
Good evening, friends. We have always seen that Mr. M. Karunanithi, an advocate, member, Law Commission of India, Special Public Prosecutor for CBI cases in High Court, and Senior Panel Counsel, Union of India. His sessions have a deeper insights into different perspectives of law. And as we see that the coming into being of BNNS 2023, and what are the aspects in respect of Bharatiya Nagrik Suraksha Sanhita, what we call as BNSS. Today's session would be revolving around timeline in this regard. And we are thankful to Mr. Karunanithi, who has accepted our invite to share his knowledge on this particular aspect. And since it's a new topic, we are quite sacrosanct that a lot of people would actually gain from today's session. Keeping in view the fact that Mr. Karunanithi has immense knowledge and he takes his knowledge and shares the knowledge amongst all of us. Over to you, Mr. Karunanithi. Thank you. Your friend has joined. Karuppa Swami has joined. Yeah, over to you.
Good evening, friends. My sincere thanks to this group for having given me this nice opportunity to meet the learned members of the bar across the country. Today is a very special day. Tomorrow is very, very special day for the country. I think tomorrow is the very, very special day. All the three criminal laws is coming to force on 1st July 2024. So tomorrow we have to celebrate as a birthday. We have to celebrate tomorrow. There are major changes in the major criminal acts with a view to get progressive back in the administration of criminal justice system in India, namely the Indian Penal Code 1860, the Indian Evidence Act 1872, and the Code of Criminal Procedure 1973. Instead of all the above three laws, let us have Bharatiya Nagarik Suraksha Sanhita 2023, Bharatiya Nyaya Sanhita 2023, and Bharatiya Sakshaya Adhinayam 2023. The Indian Penal Code 1860, the Indian Evidence Act 1872 were enacted and passed by the British for the furtherance of their own political and economic interest in India and perpetuate the British rule forever. It is better late than never that more than 75 years after the independence from the clutches of the foreign yoke, to make freedom worth its name, we have brought forth our own criminal justice system to provide enhanced protection for the poor, marginalized and vulnerable, and also cracking down the organized crime, terrorism and other high-tech offenses. The new criminal laws have been introduced. The law of a country has to be organic, so development in law by way of new enactments and amendments are inevitable. No doubt, change is permanent and change alone is permanent. A developing country shall have effective criminal justice system. Hence, effective criminal laws are just and necessary in order to have effective criminal justice. All the criminal offences are considered to be committed against the state. Hence, the prosecution is taken care by the state. It is the duty of the state to protect the people from crime and to punish the offender through the procedure established under law. It is well established criminal jurisprudence that many criminals can escape, but not a single innocent should be punished. Therefore, fair trial is imminent and mandatory. To ensure fair trial, the internationally renowned Tamil poet and philosopher Thiruvalluvar, in his magnificent Thirukural, with 133 chapters and 1330 couplets, have devoted many couplets, especially the whole chapter with the title Justice is devoted, and to realize the essence of jurisprudence, he suggests that in couplet number 355, எப்பொருள் எத்தன்மை தாயினும் அப்பொருள் மெய்ப்பொருள் காண்பதறிவு. Whatever be the matter of whatever quality, true wisdom is to see its reality. It makes it clear that the true mark of wisdom is to find out the profound truth of varied things. The popular saying in Tamil that கண்ணால் காண்பதும் பொய், காதால் கேட்பதும் பொய், தீர விசாரிப்பதே மெய். That means whatever seen and whatever heard need not be true, but what is elicited through proper enquiry alone shall only be true. It has been endorsed by Thiruvalluvar in the said couplet. Further, the worthwhile guidelines have also been given by the famous Tamil poet Thiruvalluvar in couplet numbers 541, 548, 549 and 550. These are all under chapter 55 titled Justice. Regarding appreciation of witnesses and finding by the king, so the same are very, very important. I want to repeat in Tamil. ஓர்ந்து கண்ணோடாது இறை புரிந்து, ஓர்ந்து கண்ணோடாது இறை புரிந்து, யார் மாட்டும் தேர்ந்து செய்வதே முறை. எப்பொருள் யார் யார் வாய் கேட்பினும் அப்பொருள் மெய்ப்பொருள் காண்பது அறிவு. To discern the truth in everything, by whomsoever spoken is wisdom. குடிப்புறம் காத்தோம்பல் குற்றம் கடிதல் வடுவன்று வேந்தன் தொழில். கொலையிற் கொடியாரை வேந்து ஒருத்தல் பைங்கூல் கலை கட்டதலுடன் நேர். That is enquiring, favoring no one, being impartial, consulting and rendering justice is just rule. The inaccessible and unrighteous perishes the disgraceful grief. Guarding subject and curbing crimes are not fault, but king's duties. The duties of a king are protecting his subject from enemies and punishing the wrongdoers. Passing death sentence, couplet number 550 is very, very relevant. Passing of death sentence on cruel murderer is like removing weeds from green fields. No doubt the offender should be punished. There may not be any quarrel over this from any quarters. In criminal trial as well in appeal stage, we used to raise a plea regarding the delay. The delay in investigation, delay in forwarding the documents to the court, especially when there is a delay in forwarding the first information report and the material documents like the statement of star witnesses and the Caesar magazines, forwarding the delay of confession statement and discovery of material objects will be looked into with some colored eyes. So there should not be any delay in the stage of investigation, as well there should not be any delay in filing the final report, and there should not be any delay in conducting the criminal trials. You please consider, when a person is called from a remote village, if suppose a rustic woman is called to depose before the court of law after several years. You see the memory of such a person after 5 years or after 10 years. If a prosecution witness depose so properly, the defense will challenge such a evidence as parrot-like evidence. So these witnesses should not be relied upon. If there are some contradictions, still the defense will say there are some contradictions, though these evidences cannot be relied upon, and the evidence of such and such witnesses to be rejected. So if prosecution is coming up with exact version what have been given before the investigating officer, we used to challenge as a parrot-like evidence. If there are some contradictions, still the defense will challenge it. So according to the Honorable Supreme Court, if there are some contradictions in the witnesses, in the evidence of a particular witness, then those witnesses are honest witnesses. So no doubt there should not be any delay. Any delay. Delayed justice is no doubt a denied justice. This is a well-established principle of law. So since there are many timelines have been given in Bharatiya Nagarik Suraksha Sanhita 2023, as well there are many significant welcoming features are inbuilt in BNNS 2023, BNSS 2023. We the members of the bar and the citizen has a duty to welcome those criminal laws. Bharatiya Nyaya Sanhita Act 45 of 2023, Bharatiya Nagarik Suraksha Sanhita Act 46 of 2023, and Bharatiya Sakshaya Adhinayam 2023, Act 47 of 2023 have replaced the Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act 1872. As per the well-established principle of law, delayed justice is denied justice. We have to see there are more than 5 crores of cases are pending disposal in our country. We know the value of Article 21 of the Constitution of India. Fair trial has been guaranteed under the Constitution of India. We know the fair trial includes fair investigation as well as speedy trial. Unless the investigation is fair, we cannot get, there may not be fair trial. And in order to have a fair trial, the investigation must be conducted on timeline, and the criminal trial should be conducted in a speedy manner. By judgment reported in the AR 1979 Supreme Court, page 1369, and in Motilal versus State of Jammu and Kashmir, 2007, Volume 1 SEC, page number 91, right to see speedy trial, a facet of Article 21 that has been decided by the Honorable Supreme Court. My friends may raise a question. In the Code of Criminal Procedure 1973, timelines are very much available. Section 468 CRPC speaks about taking cognizance after the period of limitation. Section 473 speaks when the delay can be condoned. So, how Bharatiya Nagarik Suraksha Sanhita 2023 is a better law? What are all the timeline have been given in BNSS 2023, which are not available in the Code of Criminal Procedure 1970. No doubt, Section 468 CRPC 1973 speaks about limitation, but the limitation is not an absolute one. In order to condone the delay, Section 473 speaks about two limbs, as per the second limb, a duty is passed upon the trial court whether the delay is to be condoned or not. It is not the section 468 CRPC is not an absolute one. As per the judgment of the Madras High Court in Pasupati versus State, delay can be condoned even in the absence of an application moved by the investigating officer. No doubt, not in the name of limitation. There are so many restrictions from the FIR, investigation, filing of final report, taking cognizance on the complaint by private individual, taking cognizance on the complaint by public servant, and till the conclusion of trial as well, even after the completion of trial, there are many restrictions available in the Code of Criminal Procedure 1973. No doubt, all the restrictions are all very much available in BNNS 2023. One of such restrictions, investigation, we say there are some restrictions in the Code of Criminal Procedure, more particularly, section 167 2A2 CRPC speaks about default bail. It says about speedy investigation, but if the final report has not been forwarded within 60 or 90 days, the person who is under custody after 60 or 90 days has to be released on bail. But in Ekta Kabur versus State of Bihar, by judgment dated 20/10/2022, the Honorable Apex Court has held traditional methods would not be sufficient to decongest the pending cases in the court. 80% of fresh filing in the constitutional courts are only criminal matters. High courts are clogged with bail and section 482 matters. According to the Honorable Supreme Court, novel methods needed to decongest the court. To my view, the novel method, the novel idea, the novel act is Bharatiya Nagarik Suraksha Sanhita 2023. There are many timelines have been given. So hereafter, there will be a speedy investigation. There will be a speedy trial in terms of Article 21 of the Constitution of India. I want to quote few judgments, very recent judgment of various high courts and also from the Honorable Supreme Court of India. By judgment dated 18/6/2024 in Devendra Baba versus State, Honorable Rajasthan High Court uphold the acquittal in a dacoity case which was registered in the year 1988. By judgment dated 31/5/2024, the Honorable Allahabad High Court uphold the acquittal in a murder case, State of Uttar Pradesh versus Sugar Singh and others. Case was registered in the year 1982. In April 2022, court in Bihar was pleased to acquit a man from a charge of murder for lack of evidence after he spent nearly 28 years in jail. Very recently, the Honorable Bombay High Court sought for an explanation from the principal court for 8 years delay in a POSCO case on unequal distribution of cases to special court. Unequal distribution of cases to special court. That is why there was a delay of 8 years in disposing the case which was registered under the POSCO Act. So no doubt there are many cases pending investigation and there are lakhs of cases pending trial. In 2017, the Honorable Supreme Court came down heavily in Hussain versus Union of India. In Hussain versus Union of India, 2017 SEC 702 regarding the speedy conclusion of criminal trials and appeals, the Honorable Supreme Court has held, in view of the directions already having been issued by the Supreme Court in a number of cases on this issue, High Court must frame guidelines and take steps to effectuate those directions. Hence, all the High Courts were directed to frame annual action plan fixing a tentative time limit for the subordinate courts for conducting criminal trial of persons in custody and other long pending cases and monitor implementation of such timelines periodically. So my respectful submission before the August gathering is that we, the people of India, no doubt we, the members of the bar, worried about the pending cases. These three criminal laws are victim-centric laws. Citizen-centric laws have been now introduced. Right from the registration of FIR and throughout the investigation and after the final report has reached the Honorable Court and after the trial, there are many timelines have been given. The friends will accept, my friends will accept the cyclic of criminal trial. As soon as FIR is registered, prosecuting agency is deriving the power of investigation. There is a delay in registration of FIR. There is a delay in examining the witnesses. There is a delay in conducting medical tests. There are delay in examining the witnesses. There are delay in forwarding the documents to the court, as well the delay in forwarding the Caesar Magajar to the court. All these things will be taken note of by the trial court in order to reject the prosecution version. If we look at the tabular column given in the web, the percentage of conviction is far below. As a citizen, we must have some worry to avoid all these things. These timelines have been given. Section 173 speaks about registration of FIR in a cognizable cases. 173 subclass 3 speaks about preliminary inquiry. BNNS 2023 recognized the preliminary inquiry for the first time. Let me read section 173 subclass 3(1). Proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days. In the name of inquiry, in the name of preliminary inquiry, number of complaints are pending before the police station. We used to move the Honorable High Court by quoting section 482. We request the Honorable High Court has to pass orders under section 482 CRPC for a directing the investigating officers to register FIR, to complete the investigation and to file final report within the time fixed by the Honorable High Court. As well, we also used to file application under section 482 CRPC for a direction for speedy trial and to complete the trial and to give verdict, the direction to the learned trial judges as well to the appellate court to complete the matter within the time fixed by the Honorable High Court. Now, we used to challenge the summons issued by the prosecuting agents. We have also challenged a number of writ petitions and application under 482, challenging the summon issued by the police. We used to say, unless FIR is registered, police cannot issue summon. Summon can be issued under section 41A CRPC. Section 160 CRPC, summon can be issued only to the witnesses. So, in so many ways, the investigation and the summons issued by the police have been challenged. Now, many summons have been quashed by the High Court, holding that the case is under preliminary inquiry for a quite long time. So, to make a full stop, section 173 subclass 3 once speaks about the preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter or not. The inquiry has to be completed within a period of 14 days. This is a milestone. And we used to do, when final report has been placed before the Honorable Court, the learned judge has to take cognizance on applying judicial mind into the facts of the case. Immediate after the cognizance, summons will be issued to the accused, and as soon as accused appeared, copies of the prosecution documents will be furnished to the accused free of cost, no doubt. After that, only charges can be framed by the learned magistrate. If the case is triable by the court of session, case has to be committed to the court of session, no doubt. If two or more persons are arraigned as an accused, there are possibilities to delay the trial. The copies of documents will have to be furnished to the accused when all the accused are appearing before the learned magistrate. If one of the accused absent himself, there will be a delay in supply of copies itself to the accused. If many persons have been arraigned as an accused, in a case which is triable by the court of session, then there are possibilities to absconding, to absent one after another. So there will be a delay in committal of the case. And even after the furnishing of copies, and framing of charges, in order to delay the trial, the accused may file an application for discharge on the day fixed for framing of charges. Even after the framing of charges, accused may file an application for discharge, holding that at any stage is the language used in the provision. So the application can be maintained. So even many cases, due to pressure on the work, there are delay in framing of charges. There are many delay even after years together. There was delay in committing the case to the court of session. We have moved application before the Honorable High Court for a direction to the learned magistrate to commit the case. I myself moved the application before the Honorable Madurai Bench of Madras. There are many cases flooded in the learned magistrate court. After the committal, even before the sessions court, the accused may file an application under section 317 of CRPC to condone the absence, to dispense with the personal attendance of the accused, one after another. So there are many ways to delay the trial. Delay tactics can be adopted by the accused. I request the learned members of the bar to kindly go through the judgments, any judgment, reported judgment of any High Court, as well the judgment of the Honorable Supreme Court, and please verify when the case was registered, when the committal was made, when the trial was conducted. In many cases, after several years, case was taken up for trial and summons have been issued to the witnesses. In most of the cases, the witnesses are from remote villages. So they may not be able to recollect what they had seen actually, and they cannot any chance to refresh their memory. So there may not be proper evidence before the court, and we used to attack. We, the learned members of the bar, learned members, used to attack the person who are coming from villages, even rustic women are called upon to depose evidence quite long when the case was registered quite long back. So with a view to overcome this, after going through the various judgments of the Honorable Supreme Court of India and judgment of the various high courts, the lawmaker so carefully and so cautiously framed many timelines available in BNNS 2023. Let me tell one by one. 173 subclass 3, 184 6, 184 2, 184 6, 185 subsection 1 and 5, 186 3, 186 4, 193 9, 194 2, 196 proviso 6, proviso to section 218 1b and 230, 231, 232 1d, as well section 497 subclass 25, which is for disposal of property, Section 262, in warrant case, application for discharge can be filed within 60 days. Charges to be framed within 60 days. Service of summons through, no doubt, in many cases, that too in cases triable by the court of session, the witnesses may not be identified. The cases are pending service of summon. In many cases, summon to the investigating officers are pending. So, as per the new provisions, 2 registers, one has to be maintained by the police station and another in the court. The service of summons through electronic methods, to the electronic means, so that the service of summons is very easy, and the summons can be issued to the investigating officer when IO is transferred to other district. It is very easy to serve the summon to the investigation officers. And in many cases, medical examination of victim of rape, section 184 subclass 2, the registered medical practitioners to whom such a woman is sent shall without delay. The word without delay has been coined in section 184 subclass 2, and subclass 5 speaks about the exact time of commencement and completion of examination shall also be noted in the report, and 184.6 speaks about the report of the medical practitioner shall within a period of 7 days has to be forwarded to the investigating officer. So, as per section 5, commencement and completion of investigation has to be noted in the report, and the report has to be forwarded within a period of 7 days to the investigating officer. So, immediate after getting the report, final report can be filed. In many cases, final report has not been forwarded to the court, though examination of eyewitnesses, examination of all the witnesses are completed. For getting the report from the official witnesses, report from the scientific experts, the investigating officer used to wait and to file final report. And in some cases, the final report has not been filed. For the simple reason, sanction to prosecute has not been occurred. The law speaks, unless there is a sanction, no court shall take cognizance of offences without a valid sanction. So the prosecuting agency cannot forward the final report unless the sanction is accorded. So in many cases, the file is pending before the officer concerned for according the sanction. The BNNS 2023 speaks about the sanction to be accorded in timeline. If not done, there is a presumption that the sanction has been accorded. Let me read section 185, search by police officer. It speaks about it must be done undue delay. If search is done by the police officer, the copies of record made under subsection 1 or subsection 3 shall forthwith but not later than 48 hours be sent to the nearest judicial magistrate, empowered to take cognizance of offences. Search, very, very important process in the investigation. If search report is forwarded to the court with some delay, it will be looked into with suspicion. So as per the new provision 185, it has to be done without any delay. The search must be done without undue delay, and the copies has to be forwarded forthwith. The language is very, very important. The copies of any record made under subsection 1 or subsection 3 shall forthwith but not later than 48 hours. Not later than 48 hours. And 186 speaks about if the officer in charge of the police station believe that delay is occasioned by an officer in charge of another police station, as per 186(4), any officer conducting a search under section 3 shall forthwith send notice to the search to the officer in charge of the police station. And 187 speaks about forwarding the accused within 24 hours. That is as usual. Then 193, 167(2) and 167(5), stoppage of investigation in a summons case has been retained in section 187 subclass 9. 193 is relevant. 193. Every investigation under this chapter shall be completed without unnecessary delay. FIR investigation begins with 173 and final report under section 193. It has to be, every investigation under this chapter shall be completed without unnecessary delay. 193(1) and 193(9). Further investigation. If in case of further investigation, the same shall be completed within a period of 90 days, which may be extended with the permission of the court. Police to inquire and report on suicide, section 194, with the report 24 hours. With 24 hours has been given in the provision 2 to section 194, and 196, inquiry by magistrate into cause of death. Section 6 speaks about the magistrate or the executive magistrate or the police holding an inquiry or investigation under subsection 2 shall within 24 hours of death of a person forward the body with a view to its being examined to the nearest civil surgeon. So the body of the deceased has to be forwarded to conduct autopsy within 24 hours. In case of 196 of class 6. In case of sanction, section 218 1B, proviso to Section 218 1B speaks about provided further that such a government shall take a decision within a period of 120 days. 120 days from the date of the receipt of the request for sanction, and in case it fails to do so, if the sanction shall be deemed to have been accorded by the government. Provided further that such a government shall take a decision within a period of 120 days from the date of the receipt of the request for sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by the government. Thereafter 230, 231. Section 227. 227 speaks about issue of process, commencement of proceeding before the magistrate. No process. Section 227 subclass 4. The process fee shall be issued. Process shall be issued unless the fees are paid on time. If not paid within a reasonable time, the magistrate can dismiss the complaint. 227 subclass 4. 230. 230 supply to accused a copy of the police report and other documents. Let me read section 230. The intention of the legislature can be inferred in any case where the proceeding has been instituted on a police report. The magistrate shall, without delay, and in no case beyond 14 days, and in no case beyond 14 days from the date of production or appearance of the accused. The calculation of day also given in the provision. 14 days without delay, and in no case beyond 14 days from the date of production or appearance of the accused, furnished to the accused and the victim if represented by the advocate, free of cost, a copy of the following. So, section 231, 231 subclass 231(1), where in a case instituted otherwise than on a police report, that is on complaint, it appears to the magistrate issuing process under section so and so and so is a tribal exclusively by the court of session. The magistrate shall forthwith furnish to the accused. Shall forthwith furnish to the accused and commitment of case to the court of session. Section 232, 232 1D, provided that the proceedings under this section shall be completed within a period of 90 days from the date of taking cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days for the reasons to be recorded in writing. The lawmaker so cautiously coined the word, if time is to be extended, there must be a reason, the reasons to be recorded in writing. So for all reasons, the time cannot be extended. So in stricto sensu, section 232D mandates the learned magistrate has to complete the committal within a period of 90 days from the date of taking cognizance. From the date of taking cognizance. From the date of taking cognizance. 262. Then 262. When accused shall be discharged. This chapter 20. Trial of foreign cases by magistrates. When accused shall be discharged, the accused may prefer an application. The accused may prefer an application for discharge within a period of 60 days from the date of supply of copies of documents under section 230. I already read section 230. There is a timeline in furnishing the copies of the document to the accused. Immediate after the supply of copies of documents under section 230, the accused has to file an application for discharge within a period of 60 days. So thereafter, definitely law mandates charges has to be framed. So this is a mandatory provision. Section 263 BNNS 2023. Let me read. He shall frame in writing a charge against the accused. He shall frame in writing a charge against the accused within a period of 60 days from the date of first hearing on charge. From the date of first hearing on charge. All right, sir. There are timeline to conduct the trial, to complete the medical investigation, and to file a report to the IO. There are timeline to complete the preliminary inquiry, to file an application for discharge, or then if argument is heard, is there any timeline for the learned judge? Yes. Section 392 speaks. Judgment. Section 4, proviso to 397 subclass 4, provided that the court shall, as far as practicable, upload the copy of the judgment on its portal. The judgment has to be delivered and the copy has to be uploaded on the portal, provided that the court shall, as far as practicable, upload the copy of the judgment on its portal within a period of 7 days from the date of judgment. So to deliver judgment and to upload the judgment, there are timelines have been given. Then section 497, disposal of property. Sundaribai Ambalal case, let us remember the judgment of the Honorable Supreme Court. The order for custody and disposal of property pending trial in certain cases, 497 subclass 2, the court or magistrate shall, within a period of 14 days from the production of the property referred to in subsection 1, before it, prepare a statement of such property containing its description in such form and manner as the state government may rules provide. Then subclass 5, the court or magistrate shall, within a period of 30 days after the statement has been prepared under subsection 2 and the photograph of the video or the videography has been taken under subsection 3, order the disposal, destruction, confiscation or delivery of the property in the manner specified hereinafter. So there must be an order of disposal of property under section 497. The report has to be prepared within a period of 14 days and within a period of 30 days there must be an order of disposal of property. So right from registration of FIR, completion of preliminary inquiry, conducting medical examination, there are timeline to furnish the copies of document, to file discharge application, and within 60 days charges has to be framed as per section 251. So there are many timelines given in Bharatiya Nagarik Suraksha Sanhita 2023 which are mandatory in nature. We have to read the provisions with the statement of object and reason, and these new timelines have to be read conjointly with the Article 21 of the Constitution of India and the judgment rendered by the Honorable Supreme Court in many cases. So we can easily come to a conclusion that these provisions are mandatory, and so definitely hereafter there may not be any delay in conducting the investigation, in completing the trial. As I already stated, there is a duty on the government, that is, as quoted in the famous Tamil poetry Thirukural, the king, the power and duty of the king has been quoted in couplet number 450. That is why I welcome the changes made in 3 criminal laws. So as a lawyer practice in the criminal side, I welcome the timeline given in the Bharatiya Nagarik Suraksha Sanhita 2023. No doubt the timeline in the form of restrictions available in the Code of Criminal Procedure 1973 are also available in BNNS 2023. We hope from tomorrow onwards, let us have speedy investigation and the speedy trial. With this, I conclude. I once again record my sincere thanks to the organizer for having given me this nice opportunity. And I also thank the learned members of the bar who have also joined on Sunday this with me. Thank you very much.
Thank you for sharing your
Jai
knowledge.
Hind, Jai Bharat.
Jai Bharat. And I'll ask Mr. Kuppaswamy to share his intakes, a dear friend of yours. And there are a few questions in the chat box. You can take those questions also.
Yes, sir. Please forward it to me.
This is CUG number allotted to a government official as how summons will be served on time is not given in BNNS. What is your take on that?
I will go through it.
Another is
first hearing, meaning of first hearing, after furnishing the copies of document to the accused, a day will be fixed for framing of charges. That will be the first hearing. Let me have, sir, please forward all the questions. I will send my answer in the YouTube.
Yeah,
first hearing, yes, sir. First hearing, my learned brother asked, Mr. Muthu asked, first hearing meaning of first hearing. That is not the day when the accused appears. Immediate after the furnishing of the copies, the day will be fixed for framing of charges. So that day we have to calculate as a first hearing. From the date of furnishing the copies, strictly we have to calculate for filing the discharge application. If we go through the provisions for discharge in stricto sensu, there may not be any case for discharge.
So thank you for sharing your knowledge, and we have shared our WhatsApp number where you can get connected with us for the latest updates on the sessions like these, coupled with the fact that you can also get the link for the YouTube channel of Beyond Law CLC, where you can take a deeper dive into the sessions done by Mr. Karunanithi and a lot of other speakers. Thank you, everyone. Stay safe, stay blessed. We hope that the new acts usher a better society, better growth. Everyone stay safe, stay blessed. Namaskar.